This is the Ontario Parliament Television Network.
Good afternoon and welcome to the Government Agencies Committee. And this afternoon we will be hearing from deputants on the agency review for the Human Rights Tribunal of Ontario. All right, our next presenter, the Accessibility for Ontarians with Disabilities Act Alliance, and David Lepofsky, the Human Rights Reform Representative. Good afternoon, Mr. Lepofsky. As you will know from the earlier deputants, we have 30 minutes set aside, and you will have the opportunity to make comments in that time, and whatever remains will be divided amongst the caucus. So please begin when you're ready.
Okay. Good afternoon, members. My name is Orville Endicott, and it falls to me to introduce to you our main presenter this afternoon, David Lepofsky, and also our other colleague, Leslie MacDonald. If I may just say a word about myself first, I'm not part of the leadership of the AODA Alliance, but I am one of the architects of it. And when I say a few words about Mr. Lepofsky, you'll get a sense of the history of how the AODA Alliance came into being. My other colleague is Leslie MacDonald, who's the National Coordinator of Accessible Design Services for the Canadian National Institute for the Blind. And she has with the blessing of CNIB, made her skills available to the coalition, to the AODA Alliance for its work. Now, David Lepofsky, who is going to be presenting to you today, he's a graduate with honors from Osgoode Hall Law School and went on to do a Master of Laws at Harvard Law School in the early 1980s. Even before that, he was very active in a volunteer capacity and continues to this day to be a volunteer advocating for reforms to the law that will secure better rights for people with disabilities. He was one of the most articulate and persuasive voices that gave us in the Canadian Charter of Rights and Freedoms the guarantee of equality for persons with disabilities. He had the same impact here in this province, and with respect to the inclusion of protections against discrimination on the grounds of disability in the Ontario Human Rights Code. If I were questioning him, I might ask him how long is it going to take him to get Canada to ratify the United Nations Convention on the Rights of Persons with Disabilities, which was passed at the UN and signed by Canada more than 2 years ago. From beginning in the mid-1990s, David was the organizer and driving force in the Ontarians with Disabilities Act Committee. And that committee achieved through the Conservative government in the 1990s the Ontarians with Disabilities Act 2001. And then, of course, he went on to ensure that we have the Accessibility for Ontarians with Disabilities Act, the AODA, passed in 2005. Whenever I ride on the Toronto Transit Commission subways or buses, I can't help thinking of David, because I take advantage, just like people with visual impairments do, of the very clear and timely announcement of every stop. It's a very dulcet and clear voice that I hear, but it's really David Lepofsky's voice, which you will hear in just a minute. David was the recipient of, well, I left out that we would not be hearing that voice had David not successfully gone to the Human Rights Tribunal of Ontario, first to ensure that the TTC would announce subway stops, and then a little while later that they would announce all bus and streetcar stops. David received the Order of Canada in 1995, the Order of Ontario in 2007, and too many honors for me to list. He is a prolific author, both of published and unpublished documents, one of which you have before you today, and he is the Human Rights Reform Representative for the AODA Alliance. David.
Thank you, Orville. It's an honor to be able to appear before you. You have a brief before you that we've submitted. I know this hearing is being televised. If anybody else wants to get a copy of our brief, we'd be delighted to email it to them. They need simply send a request to aodafeedback@rogers.com. We're honored to be here particularly because we wanted to make these points about 2.5 years ago at Standing Committee hearings on Bill 107, which we were promised, which the government scheduled, which the government advertised, and which the government, over the commendable opposition of the opposition, canceled through an unprecedented closure motion to muzzle public debate on human rights reform. I regret that what we are here to do today is to tell you what we were trying to warn you of 3 years ago, and which unfortunately appears to be coming true as a result of the government's changes to the Human Rights Tribunal and the related agencies it works with. The coalition with which I have the privilege of serving is made up of individuals and organizations like Orville and Leslie who some 30 years ago came to this building to fight to get disability included, discrimination because of disability, into the Human Rights Code. We were delighted to win 2 rights back in 1982. First was a legal ban on discrimination in workplace and access to goods and services and housing and the like based on disability. But that wasn't the only right we won. The second right we won was a legal guarantee that our human rights would be publicly investigated and publicly prosecuted by a public law enforcement agency called the Human Rights Tribunal. As long as the complaint was within their jurisdiction, not trivial, and incapable of being settled, their job was to investigate it and, where appropriate, to litigate it. Those were 2 important rights that we won. In the 90s, we united as a disability community to fight for and win the Accessibility for Ontarians with Disabilities Act, a new law to build on, not replace, the Human Rights Code. We're here today to draw your attention to the promises that the government made in 2006 when it decided to pass Bill 107 to privatize the enforcement of human rights, and to demonstrate through the government's own data by those responsible for implementing this law that those promises have sadly not been kept. In 2006, the government, over again the commendable opposition of both opposition parties, opted to repeal the right that we won to have our equality rights or human rights claims publicly investigated and, where warranted, publicly prosecuted by the Human Rights Commission. The government decided to privatize it, to put the job of investigating and litigating our human rights on the backs of discrimination victims themselves, a population that the government always recognized is vulnerable, disadvantaged, often impoverished, and least able to take on that privatized duty on their own. What did the government promise it would do? By privatizing the human rights enforcement process, by telling us that we had to take our cases right to the Human Rights Tribunal, investigate them ourselves, and try to get the support of the Human Rights Legal Support Center if they choose to represent a claimant, the government said that they would clear the backlog that we all agreed was too long and too big at the Human Rights Commission. The government said that this legislation would create new access to the Human Rights Tribunal, that any discrimination claimant would have the right to a hearing. Indeed, we were told about a hearing within a year of filing a complaint. We were told that the hearings would become more accessible and more fair, and we were told that as a vanguard to support this, the government was not abolishing the role of the Human Rights Commission. We were told it was going to be strengthened and it would be in the vanguard of litigating human rights cases on a systemic or public interest basis. That's what we were told by the government. And if you look at Appendix 1 to our brief, we provide quotations from the record to prove all of that. So what's happened? This is from data that we've requested from the Human Rights Commission, the Human Rights Legal Support Center, and the Human Rights Tribunal. Appendix 2 to our brief sets out the information requests. And to the extent that we weren't able to get everything we wanted because time limitations or they don't collect the data, we urge you to ask them for the same data that we weren't able to get. What have we learned? First, what we have learned is that a very substantial proportion of the people who used to come forward to approach the human rights system appear not to come forward and approach the human rights system at all. According to the annual reports of the Human Rights Commission, before it was, its main functions were eviscerated, it would receive in the mid-2000s in the range of 50 to 65,000 calls per year. That's first contact. And if somebody doesn't make first contact, they're not going to go any further. Now, what have we learned under the new system? We understand that the intake role, the first contact role, has been transferred to the Human Rights Legal Support Center. The data that they've provided to us is that in their first 6 months, they've gotten approximately 10,000 calls. It sounds like a lot of calls, but it's actually less than half that would have come in the same time period under the old system. That suggests to us, unless somebody could show that those people are otherwise engaging the system, that suggests to us that there is a substantial proportion, more than half of the people who might have come forward may not be coming forward at all, even to make first contact. That alone ought to cause serious concern for everybody. But that's not all. What's happened to the people who have come forward? We were told that the government would clear the backlog. The data that we've got on the caseload before the Human Rights Tribunal now suggests that the backlog is as big as ever. The numbers we've been given, you heard some this morning and they're in our brief, are that the new applications still not settled number about 1,000. The number of cases that jumped from the old system between June and December, still not settled. Some of them have. I'm talking about the unsettled one. Another 800. So there's 1,800. We were also told that there's another 700 and some that the Human Rights Commission has before the tribunal under the old system, but a number of them are class actions, so we boil that down to 400 to be cautious in our numbers. 2,200 cases. You file a complaint tomorrow, you join a lineup behind 2,200 other cases. That backlog is not lower than it was if you take into account the following. There are, from what the Human Rights Commission has told us, another 2,000 cases that were at the Commission at December of last year, not resolved, and the Commission has had all of its residual powers to deal with them taken away. So they've got the right to jump into the new system. Those are cases which, if they do jump in, mean that you would be in line before, if you come forward with a new case, behind 4,200 cases. Now, if you look at the statistics of the Human Rights Commission's backlog that was the subject of massive government critique, and properly so, when Bill 107 was brought forward and the number of cases that were at the tribunal, and you combine them together, you won't see that there's progress. If anything, we've got a matter of concern. Now, can they clear the backlog? You'll say this is early. Well, they've got 22 full-time adjudicators at the tribunal and 22 part-timers, and I wasn't able to get figures on how many full-time equivalents they are. But if those 22 full-timers work every day, every night, don't go to the bathroom, don't eat, and don't sleep, I don't believe that they could deliver a hearing to every complainant within the year that we were told to expect under this new system. So the government might say, oh, but it's a transition. Not a fair answer. It's not a fair answer because we warned the government and wanted to warn the legislature, but of course we were muzzled by a closure motion, that their transition provision was going to do exactly what's happening. Moreover, the government gave itself 18 months after it passed Bill 107 to try to fix this problem and proudly announced last April, that they were giving unprecedented money to fix it. So if they gave themselves the time they decided to give, gave themselves the money they thought was unprecedented, still couldn't fix it, they can't turn around and say, but it's a transition period. A new claimant is going to get into a longer backlog than ever. This is a serious, serious problem. If that alone was the problem, that would be bad enough. It gets worse. The government promised us hearings that would be more accessible. You heard Mr. Gottheil, the chair of the tribunal this morning, talk about the new rules they've adopted. We reviewed those new rules, offered detailed proposals about them, expressed serious concern, and, I regret, were mostly disregarded or our views were rejected when the tribunal set up its new rules. Given the rules that the tribunal has adopted, a discrimination claimant would be foolhardy to try taking on the Human Rights Tribunal process without a lawyer. The rules number 28 pages, I believe. They have fully 24 forms that you may be, any number of which you may have to fill out. There are detailed procedures. They are complex, and they serve as a trap for the unrepresented. I'm not saying they were meant as a trap, but anyone who goes before that tribunal unrepresented goes forward at their own peril. They need to have legal representation, we believe. We warned the tribunal, and all the plain language in the world in their rules or their forms don't remove that need. Given that, what is the situation? What is the reality before the tribunal? Well, the government promised us that there would be free, independent legal representation for all discrimination claimants. The quotations documenting that are in Appendix 1, a 2-hour brief. Have they delivered it? Again, don't ask us, ask the tribunal. The data they gave us was that only 40% of new claimants, 40% came to them with legal counsel. The figure I believe they gave this morning may have been as low as 20%, but let's assume it's 40. Let's give them the benefit of the doubt. That means 60% of new claimants are unrepresented. That's a far cry from everyone being represented when taking on rules for which one needs legal training to navigate them and avoid risk in the presentation of your case. Now remember, under the old system, this wasn't as much of an issue because the case didn't go to the tribunal unless the Human Rights Commission investigated it, tried to settle it, and assigned counsel who was supposed to have carriage of it before the tribunal. Under the new system, you're on your own. And that is a serious problem under the new system. Now, I just talked about how many people are unrepresented among the claimants who bring new claims. What about the 900 or so people who were in the old system last June and decided to jump to the new system this fall? According to the website of the Human Rights Legal Support Center, I quote it in our brief, they opted as a matter of policy not to represent any of them. That's none of them. That's their policy. I don't know if they departed from it, but all we know is that's their policy. And that falls a far cry from full legal representation for all claimants. Now then, so we have a very serious, troubling system. The question came up this morning, and we commend those members who raised it, about what about the respondent? Is the respondent, the party accused of discrimination, are they represented? Now, let me talk personally for a moment. As Mr. Endicott indicated, I brought 2 cases against the TTC, one to get them to announce subway stops and one to get them to announce all bus stops so we blind people, and by the way, you sighted people, can know where the heck we are. Outrageous human rights claim, of course. One would have thought it so obvious they would have done it, but they didn't. Instead, under the old system, the TTC went and hired lawyers. Between the 2 cases that I fought against them, and Freedom of Information requests that I brought documented that the Toronto Transit spent a grand total, between the 2 cases, of $450,000 taxpayer dollars on lawyers to oppose calling out all bus and subway stops reliably for the benefit of blind passengers. Now, I'm not saying that every respondent's going to spend that kind of money, but many of the biggest ones can. And it is not a fair fight for an unrepresented, disadvantaged discrimination claimant who may have lost their job or trying to get access to a basic government service to be up against the muscle that can be marshaled against them when many respondents are legally represented and the complainant may not be. You asked the tribunal this morning, in how many cases is the complainant unrepresented but the respondent is, and they told you they don't have that data. We asked that same question. With respect, they should have that data. The issue of proper legal representation was a central concern during the much focused upon and covered public debates over Bill 107. And even the proponents of Bill 107, those who are on the other side of the debate from our coalition and others who support us, even many of them from the community groups agreed how important it is not to throw an unrepresented complainant in against a represented respondent. Time is short. Let me jump to some other considerations. Again, if all of that was bad was the only thing that's gone wrong, it would be bad enough. But I regret it gets worse. When the government brought forward Bill 107, the government and its proponents said that one of the big problems with the old system was that there was a gatekeeper at the gate of the Human Rights Tribunal. It was the Human Rights Commission that would decide which cases went forward, and they repeatedly talked about how few cases actually go to a hearing. They said the new system would have no gatekeeper. We believe the data before you will show that they've just changed gatekeepers. There's a new gatekeeper. It's called the Human Rights Legal Support Center. They get 10,000 calls in 6 months. They do, I am sure, the very best they can. They are dedicated and hardworking people. They interview, I believe, a proportion of the people who call them. They've advised a smaller proportion, and they have ultimately drafted complaints or applications for, we've been told, about 200 or so applicants and another couple hundred more coming. A very small fraction of the 10,000. That is de facto a gatekeeper role. Now, again, if that was bad enough, we'd have a lot to be worried about, but it gets worse. We were told the Human Rights Tribunal would adopt proceedings that would be fair. The Human Rights Tribunal, over our objection and those of many other community groups, opted to use the power that the government gave it to override the requirements of fairness in the Statutory Powers Procedure Act. Mr. Godheil this morning made it sound like we're trying to come up with old technical criminal law proceedings at the tribunal. Far from the truth. With respect, it's just not our position. We want some basic fairness. And we quote in our brief one ruling that should give members of this committee concern. I don't want to talk about the merits of the case. I don't know anything about the merits of the case. But in a case called Prasad, one tribunal adjudicator, a Mr. Mark Hart, decided before a hearing began to dictate to the parties how long they could examine in chief or cross-examine each of the witnesses listed. An hour for this one in chief, an hour in cross, a half hour here in chief, a half hour in cross. And he said, if you've used up your time or if you're not happy with this, I'll consider an extension, but you've got to first identify that you use, or prove to me that you used your time effectively. Now, with respect, and I'm not commenting on the merits of the particular case there, this is exactly the kind of potentially unfair proceeding about which we are very concerned. It is impossible in advance to have an adjudicator who does not know the witness, hasn't interviewed the witness, doesn't know all of the ins and outs of the case, to know better than counsel calling the witness how long they need to examine them or cross-examine them. The tribunal gave same time for chief and for cross. It's not unusual in cases for a witness to be very short in chief, very long in cross, or the other way around. And finally, the tribunal, deciding that they would that they would give people the opportunity to ask for an extension after or near the end of their time, after they've already used it up, puts counsel in a hopeless position. You've got to know how much time you've got before, not after you've used it. The last area of concern, I know my time's just about up, but I just want to talk about my last area of concern. A hugely important issue. By the way, I can't say how prevalent that practice is. I'm just simply advising that that is a decision which is an indication of an area of concern which merits, I believe, more attention by this committee into the powers the tribunal is using. Now, final area of concern, public interest remedies. It's not enough when somebody is discriminated against, if they prove their case, to give them some money and say, go away. If that happens, the claimant may be happy to get some money and go away, but that doesn't prevent it from ever happening again. That's why we need public interest remedies. The party that was in the lead of seeking public interest remedies under the old system was the Human Rights Commission. Now, of course, they're ahead of the game for most of these. We are very concerned. We wrote the tribunal and asked how many cases they're giving public interest remedies in settlements, and we haven't got any answers on that yet. We hope they're able to pull that information together. But, of course, there are 6 reasons that I'm going to summarize, and then I'll conclude, why you should be very concerned about this under Bill 107. First, the government said that under Bill 107, the Human Rights Commission, even though it was out of the business of dealing with individual cases, would be in the vanguard of bringing public interest cases. Guess how many they've brought under Bill 107? 0. That's their number, not mine. Under the old system, they've got one still outstanding. They've done one inquiry so far, but they've brought 0 commission-initiated complaints so far. So that's one of my 6. Number 2, the government said that the Human Rights Commission could intervene in individual cases. This was an avenue, for example, to bring forward public interest concerns. How many of the 1,200 new applications have they intervened in under the new system? According to the Human Rights Commission, 1. Well, it's 1 more than 0. The government told us that the Commission would retain investigative powers. But look at schedules or appendices 4 and 5 appended to my brief. They've laid off all their investigators. How can they investigate without investigators? 4th, the government said that the Human Rights Commission would be empowered to do this through 2 new secretariats that Bill 107 requires them to establish. The Anti-Racism Secretariat and the Disability Rights Secretariat. You go down to the Human Rights Commission, you can go all through the building and look for them. They don't exist, contrary to the requirements of the Human Rights Code. And finally, only have time for 5. Finally, the government said that we could be confident that disability would be a priority amongst the Commission's work. You'll see that while they have done some important work in disability, and I'm sure they'll do some more, their priorities set out in their strategic plan, which we quote, sets mental health as one of their priorities, but no other disability issues, a bunch of others. And we're very concerned that we're going to fall potentially to the lower end of the priority spectrum. Let me conclude by thanking you again for giving us the opportunity. I wish we would have been able to do this 3 years ago. And we welcome the chance to come back to talk more about this as you get more data. We encourage you to have full hearings. Invite not just those of us who are here today, but anyone else who was of the hundreds of groups who were frozen out. And finally, we encourage you to, on all sides of the House, to unite, to have the government keep the promises that it said it would under Bill 107. Thank you very much.
Well, thank you very much. And you did mention that you had 6 and that you went to 5. We are certainly here to hear number 6 if you want to add
Okay,
that.
that's fine. I just want to make sure I didn't go over my time.
No,
All
go
right.
ahead.
6th concern is this. This is really fundamental to us. Remember I said that the Disability Act that we fought for and won and proudly won in 2005 was the underpinning of it was the Human Rights Code. And we're very proud that the government brought it in, and we're very proud that both opposition parties united to support it. That was an incredible day back in 2005 when it was passed. Let me talk about what happened leading up to that bill. One of the things that Premier McGuinty promised our coalition in the 2003 election was that that Disability Act would have effective enforcement. When Premier McGuinty got elected, his government asked us what effective enforcement we wanted. We said we would like a new enforcement agency to enforce the accessibility requirements independent of the government. In long discussion with the government, and the government ultimately elected not to give us that new enforcement agency. And I was the lead negotiator for our side of the table. They were very good negotiations, and in good faith, we were told, I believe, the government believed that we would have enough to be able to continue to use the investigative and prosecutorial functions of the Ontario Human Rights Commission. Everything we wanted in that bill, but we shook hands and celebrated its passage as an overall good deal. A year later, the government turned around and ripped out the Human Rights Commission's investigative teeth and its enforcement teeth. In other words, the very enforcement agency that we were supposed to be able to fall back on was essentially eviscerated. And that, we say, is not fair. It undermines the Human Rights Code, but it also undermines the Disability Act, for which all 3 parties so properly and wisely united to pass. And that is a breach of faith. It is a breach of commitment. It is fundamentally unfair. It is also something that we wanted to come and be able to say to a committee of the Legislature 3 years ago. Only a closure motion precluded us from being able to say it in here. We had to do it at press conferences or letters to the editor.
Well, thank you very, very much, and we appreciate your being here today. As you might have realized, we have exhausted the time that is available, but I'm very pleased that we were able to offer you the opportunity to make your final comment. And thank you very much for being here with us today. Ladies and gentlemen, that concludes the business for today. The committee stands adjourned until you have the closed session at 9, the open session at 9:30 tomorrow.
This is the Ontario Parliament Television Network.